Hi, everyone. I'm attorney Donna DiMaggio Berger, and this is Take It to the Board, where we speak condo and HOA. Dennis Eisinger founded Eisinger Law in 1996 and serves as the firm's managing partner. For the past 4 decades, he has represented all types of community associations throughout Florida. Dennis also represents developers, financial institutions, and private equity clubs. He is board certified in condominium and planned development law by the Florida Bar and is an adjunct professor of law at the University of Florida's Levin Law School. I've had the pleasure of knowing Dennis for many years, and I'm excited to have this opportunity to have him on the podcast as our guest. Dennis, welcome to Take It to the Board.
Thank you. It's wonderful to be here. Thank you.
Now, Dennis, you've acquired an expertise across so many different practice areas throughout your legal career. But for the last decade, you've really carved out a niche in terms of addressing the issue of secondhand smoke in multifamily buildings. Now, living in a condo or a cooperative means compromise at times. You might smell your neighbor's cooking or hear your neighbor's music, and unless those activities rise to the level of a general nuisance, you just live with it. So what makes smoking a different problem altogether?
Well, no one likes to cough unnecessarily or have their clothes or carpet or furniture smell, but the real issue is just health and safety, health concerns. We know, or most of us know, that secondhand smoke certainly can kill and or can make people ill. I became sensitive to that quite a long time ago when I learned about the medical research and second and third hand smoke as well. Third hand smoke being the type of smoke that sticks and stays on walls, carpeting, clothing, whatever, as opposed to secondhand smoke, which is direct smoke that someone might be breathing from someone who is near them as a smoker. I became aware of the issue and the problem through partially my practice of law and the community association industry, and it became a passion for me to try to assist in at least this, one area of community association living.
I'm personally also very allergic to smoke, but if we've learned anything over the last 2 years, it's that people have differing views when it comes to medical data, scientific facts. How much do you think a board should rely on this issue being a health issue? Because I'm sure, as you well know, there will be people who, even if you present them with the data that second and third hand smoke is dangerous, they're not going to believe it.
That's where we are in society these days. Individual freedom to do whatever you like, supported by certain factions and other factions believing in medical research. So that's a tough one and too big for me to answer. But I will say that in addition to the philosophical beliefs regarding medical research, for example, there is individual sensitivities, and one person may never have any symptoms, experience any health issues or whatever by inhaling a lot of smoke. And then the next person could inhale just a little bit of smoke and become extremely ill. So we have to also recognize that, and we have to try to protect at the lowest denomination so that we don't, in the community association industry or otherwise, contribute to ill health.
Does a lot depend, Dennis, on the infrastructure of the multifamily building? For example, older buildings, depending on their duct system, would that more easily transmit smoke from one unit to another or into the common elements?
Yes, buildings are built better now than they certainly were 20, 30, 40 years ago. However, even in the best built building, there are ways that smoke emanates from one unit to another or into the common elements corridor of a condominium. It could be through the HVAC, the heating and ventilation system, ducts, underneath doors, crevices in windows. There's several different ways that the smoke might migrate and emanate from. It's more pronounced for older buildings, but it's still a problem even for the newer ones.
So somebody's living next to a chain smoker, let's say, and they come to the board and say, this is a nuisance. And we look at the documents and they really don't address smoking at all. I know you, like I, have prepared amendments to documents. I've drafted amendments that create an entirely smoke-free community where smoking is prohibited everywhere, including inside the units. And I've drafted other amendments that permit smoking in certain designated areas, or perhaps even out on the limited common element balconies, but only during certain times. So tell us, how do you typically structure smoking amendments for existing communities?
It depends upon that particular community and how far the association or the board may wish to go in trying to get some degree or full regulation of smoking. The Florida Clean Indoor Air Act, which was adopted in Florida in 1985, I believe, and then a tweak in the early 2000s, does presently prohibit tobacco smoke from occurring, smoking within indoor common areas of condominiums and within the workplace, if the workplace is within the condominium building. So those areas we do not have to be concerned with. However, as you say, what is left over would be the individual condominium unit, the limited common element balcony area, which would effectively be to the exterior of a particular unit, and then the outdoor areas, which might be areas joining a pool, parking lot, or whatever. So we have drafted, as I'm sure you have, many different ways. We give the kind of menu of choices to our association clients, and sometimes it's a very gung-ho type of community and board leadership where they want smoking prohibited in each and every one of those areas. In other cases, it's limited to everything except for possibly that exterior limited common element area on balconies, which is bit of a compromise for the smoker that, hey, you could smoke in an area that is the least harmful to any of your neighbors for the most part because it's outside and up in the air. Also, we sometimes, well, if I had my druthers, the smoking prohibition would be everywhere. However, sometimes it's just reasonable for the exterior to say that, well, no smoking within the pool area or the pool apron area or within 15 feet of that area, areas where there's a tendency for there to be children or adults congregating. So it really depends upon the particular community, and we let the community or the leadership advise us as to what they think would be best and, very importantly, what they think can obtain the requisite approval of the amendment, because it doesn't do any good to say no smoking anywhere and everywhere, and because of that, you're not going to get your majority vote or two-thirds vote that might be needed in order to pass the amendment.
Or it's difficult to enforce. So, it's one thing passing an amendment. It's another thing having the practical ability to enforce it. But you bring up a really good point about the Clean Indoor Air Act. I think that some associations with employees overlook the fact that the common elements are the workplace for those employees. So even if it's outdoors, and let's say you've got people, pool attendants, if they're walking through a cloud of smoke every day while performing their duties for the association, that can be problematic if you're not providing a safe workplace for them.
Yeah, absolutely. And that brings to mind, and I'm an optimist by nature, but I have to believe that 10 years from now, this podcast, this information is going to be almost laughable because every condominium, every residential community association is going to be smoke-free. 1980, who would have thought that airplanes you couldn't smoke on? So I believe that eventually this is going to become the absolute norm. Condominium documents will be drafted from inception, clearly indicating it's no smoking and or through a statutory regulation.
Some of the people listening to this podcast probably remember being kids trapped in cars with their parents smoking, driving around in a smoke-filled car. But bring up a point about documents, but many of the cities in California have actually taken this burden off of associations, and the municipalities have created smoke-free task forces where if somebody is living in a multifamily building and they are next door and having a problem with excessive smoke, the city will send an officer out to address it. Think we'll ever get to that point here in Florida?
I do eventually. And again, whether it's 5 years, 10 years, or 15 years, we will eventually get it. California has been very progressive on that, or at least certain of its cities in California. In Florida, we have a condominium statute that governs and has superior jurisdiction to municipalities and counties. So any action taken through governmental authority in Florida is going to need to be through Florida's Condominium Act statewide. California, they bestow that power upon municipalities to make their own local rule for that. And that's why they're able to do that. There's one state, Utah is a state that has also effectively banned smoking in high-rises, residential community associations by state statute. So I'm not aware of any other states that have done that uniformly. There are some other cities around the country, but for the most part, you're correct. They're mostly in California and then Utah as well.
I just had Andrea Northrup on the podcast talking about our current property insurance crisis in Florida. Do you think there's any engagement in the insurance industry on this issue of smoking? I mean, obviously, we think about smoking, we think about the health risks, we think about the nuisance, but there's a real fire danger associated with people smoking inside the units, isn't there?
Certainly, and not only just from fire, but there could be other claims for other types of damages as a result that might invoke some type of possible insurance coverage. Maybe it's even a claim of breach of fiduciary duty by the board of directors for not doing something relative to a smoking issue that had been brought to their attention. So that would be perhaps a practical way where we get to a good bottom line by having the insurance company say, well, your insurance premiums are that much more if you don't have a smoking prohibition, or you can save X number of dollars by doing what you could to have your documents amended to prohibit smoking.
That might be incentive to have the membership approve a non-smoking amendment. So whenever we talk about amendments, we have to think about grandfathering, right? Who is the amendment going to impact and when is it going to impact these people? When we pass amendments, Dennis, that restrict commercial vehicles or restrict pets or guest occupancy, we always have to think, okay, somebody has a commercial vehicle. We don't make them sell that vehicle, but certainly when they go to replace it, after that amendment has been recorded and become effective, they're not going to be able to replace it with another commercial vehicle. Same thing for other types of restrictions. What's your stance on grandfathering when you're passing a smoke-free amendment?
My stance and my position is that there should be no grandfathering in, or there does not need to be grandfathering in, because this rises to a different level. It's health, safety, and welfare for all in the building, unlike another pet situation or a vehicle situation. However, I am not aware of any court that has ever decided that. There's been some judicial cases around the country here and there, and very, very little, maybe perhaps even just one in the state of Florida. And the retroactivity grandfathering issue has not been brought up. But I would say that it differs from the vehicles and the pets. It's not a matter of aesthetics or inconvenience. It's health. Smokers are not protected by any constitutional protection, U.S. or Florida. I believe that there should not be grandfathered in on smokers. With that said, I will say that in order to pass a smoking amendment, sometimes you might have to put that grandfathering language in. In my association where I live in Fort Lauderdale, small association, only 14 units, we took a vote just about 3-4 months ago, finally convinced enough people to put it to a vote. There was one smoker in the building of 14 units, but that smoker happens to have owned 2 units. And we drafted the amendment because we thought there would be sympathy for that particular individual to say that any existing smokers, i.e. that person, would be exempt and grandfathered, notwithstanding that person his 2 votes and voted against the amendment anyway, even though he wasn't affected by it, and the vote to pass it lost by 2 votes.
Right. I mean, listen, I share your philosophy on the grandfathering. For me, when I'm asked this question, well, who will be grandfathered? And depending on how, as you said, the amendment is structured, you can finish your cigarette when the amendment gets recorded in the public records. So you can finish that cigarette, can't light another one. That's been my philosophy because we're talking about a behavior. And I understand for some people there is an addiction to it. But again, the line of case law in Florida is, I think I'm quoting it liberally, a man's castle is his home, except if you live in a condominium or a multifamily building, because you really are impacting other people. But I too have seen amendments, non-smoking amendments structured where they will grandfather in existing people. People need to understand it's not a grandfathering of the unit. So if you're a smoker in a unit, it doesn't mean that your unit is a smoking unit in a non-smoking building. It may mean that as long as you live there, the smoker who lived there before the amendment was passed, depending on, again, on how the amendment is structured, you may be able to continue with that behavior. I've also had associations that are very adamant that they want the building to be smoke-free. And that means it's going to impact everybody.
Mm-hmm. Yeah, touching upon the federal laws on it, Federal Fair Housing Act, applicable to most or all community associations, as well as ADA to the extent there may be certain elements. Smokers are not a protected class. Those who are unwantingly smoking, getting secondhand smoke in them from the neighbors might be because it's a health issue to them. And so if there's any protection anywhere at the federal level, it's for the aggrieved party, not the smoker.
Have you ever had somebody request a reasonable accommodation and claim that it was for smoking?
Yeah, years ago, I don't remember how that went. That was a claim because it was an addiction. You could be addicted to a lot of things. You could be a pyromaniac and can't really help yourself from burning down buildings, but that doesn't mean you're still allowed to stay in that building.
Yeah, it has to be reasonable. So let's say an amendment is not feasible. You have vulnerable occupants in one unit. For instance, I had a situation years ago where it was a single mother with two young children. They were both asthmatic and they happened to be living next door to a chain smoker. It was an older building. The smoke was coming through. There was nothing that the owner, the chain smoker, was doing to stop it. What can owners do? What can residents do if an amendment is not possible? And I'm talking about maybe even just like air filters, things like that.
First and foremost, I would always suggest and recommend that if it's neighbor on neighbor relative to a smoking issue, that there be appropriate communication with the smoker. Knock on the door, explain why it's a problem for you, and try to convince the neighbor to eliminate smoking or eliminate smoking while they're within the condominium, or to at least minimize it. Sometimes that works. Usually it doesn't. Number two, going to your association board of directors and trying to get them involved globally on the issue, whether it be to try to lobby them into considering having an amendment considered to their declaration of condominium to eliminate the smoking. And you might have some success there, maybe not. In addition to some physical components that might be helpful, there are filtration equipment, machines out there that help to a certain extent. It's not going to ever eliminate the smoking, but it could possibly greatly minimize the smoke infiltration. There's also a structural retrofitting that sometimes can happen, whereby a company is hired to effectively fill in all the gaps under doors, windows, whatever, and to minimize the exposure through the ducts and vents in the one condominium unit to another. So all those are good ideas from the structural standpoint. Again, they're not going to be the end all, but they would help if a community wanted to go down that road. In addition to effectively lobbying and educating your board of directors, doing the same with your local legislators is not a bad idea as well. You get a hold of your representative or senator for your district, you explain the problem, and eventually we're going to get someone who is very passionate about this in our Florida legislature to run with it. I tried from year 2016 to 2019, about 4 years in a row, with different legislators who all said that's a great idea. But once they got to a certain point, they said, it's not going to happen with this particular body of legislators we have, so I'm not even going any further with it. Eventually, it's going to catch on. In fact, in this past legislative session, a couple of things happened. Within the last year in Florida, finally, Florida legislature has allowed local government, municipalities and counties to regulate or prohibit smoking within parks and beaches within their area. So that was a very good step that the legislature took. And also we have within the last year or so, Florida 21 law, which by statewide prohibits vendors from selling cigarettes to anyone under the age of 21. So I think we're starting to inch closer to where we have to be for the residential condominium industry, but we're not quite there yet. Keep on trying and do the best you could as far as trying to convince your association to consider a possible amendment to your constituent documents.
It's been my experience over the years that most owners and residents do not feel comfortable addressing a problem head on with a neighbor. So they normally, their first path is to go after the board. And it's always sort of amazed me because they'll even hire an attorney to go after the association to enforce something. For me, if I was in a unit and I was inundated with excessive secondhand smoke, I may hire an attorney to go after that neighbor directly. And I believe there's several causes of action for neighbors to do that. I know in Broward County, years ago, there was a case where an owner did just that, hire an attorney and go after a neighbor and claimed that the excessive secondhand smoke was a trespass. I believe that case settled. But what other causes of action might an owner bring directly against his or her neighbor who's creating such a nuisance for them in terms of the secondhand smoke?
The case that you're referring to, I believe, is the Merrill versus Brosser case, which just shockingly is really our only legislative case in Florida. It was decided in 2006, and it pertained to an owner versus a tenant next door. And case found a nuisance and a trespass and awarded the sum of $1,000 plus I think it was $250 of costs to the aggrieved resident and the tenant moved out. So shockingly, we don't have a lot to go on from a judicial standpoint, and the Department of Business and Professional Regulation, which regulates condominiums in the state of Florida, has been relatively passive about the issue, not wanting to necessarily consider emanating smoking from one unit to another as a nuisance or a trespass. They haven't said it's not, but they haven't gone out of their way to enforce or do anything in any declaratory action that I'm aware of. And the smoking issue comes up, the first thing we try to do is not have the association involved. And we try to urge the unit owner, look, have that one-on-one communication with your neighbor, do the best you could, and we try to keep the association out of it. However, from the legal standpoint, ultimately, the association is involved as a party because the smoke that's transmitted emanating from one unit to another is passing through common elements of the condominium. In between the two condominium units, there's going to be space beyond the walls of each unit, and that space is common elements, and the association is responsible for that, or for the space, let's say, common element area within the corridors where the smoke emanated to.
Plus, it's a nuisance. So if the association doesn't consistently and uniformly enforce the nuisance provision, assuming it's a broad enough nuisance provision in the document, you have a potential breach of fiduciary duty claim. I would imagine if the board is completely unresponsive to an owner complaint regarding excessive secondhand smoke, not just smoke. There's always going to be smoke in these buildings, right? Somebody lights a candle, somebody's cooking, they have a small cooking situation on their hands. But what we're really talking about, Dennis, is excessive secondhand smoke, right?
It depends. When you're doing an amendment, you have to be careful about how you're defining what is being prohibited. And there's some definitions that are in the Florida statutes that in preparing our proposed amendment, we use that. We like to define it as tobacco-based smoking, a hookah, and like to define it as including cigars as well, cigar smoking, generally not marijuana for other reasons. And we have to try to define it as best as possible to be as inclusive as possible.
Vaping too, I imagine, in the e-cigarettes.
Yeah. About 4 or 5 years ago, when I was drafting amendments, I didn't necessarily include that. But now the industry has become so large, and we do know that vaping emits some degree of secondhand smoke, maybe not quite as much as a regular cigarette, but it definitely also needs to be prohibited. So the causes of action that we see, as you say, is a common law nuisance. There is a right of quiet enjoyment that by common law that all unit owners are entitled to. It's a nuisance. It's a trespass of the smoke from one area of the condominium into another part of the real estate. Breach of contract. The declaration of condominium, we don't really think of that as a contract, but it is. It's a contract between the original developer and the association with the unit owners. And that contract has covenants in them, including usually the right of quiet enjoyment and prohibiting nuisances or whatever. So if there was legal action ultimately taken, then breach of contract would be a forefront claim. You get injunctive relief, specific performance. There's all kinds of machinations that you can pursue if you are the aggrieved party. And the question is, do you just try to sue the smoker, or do you go after the association as well? And I would say that while in representing community associations, we hope that we try to convince the aggrieved party that they should just bring claim against the smoker. As a practical matter, usually the association is going to be dragged in as a defendant as well.
Yeah, always happens. You mentioned cigar smoke. If I lived in a building next door to a excessive cigar smoker, I would have to move out. just that would not work for me. But you mentioned marijuana. So how is all of this analysis different when the person is living next door to somebody who's smoking marijuana and the marijuana smoker is claiming that it's medical marijuana usage?
There's a balancing of interest there with a lot of things involving Federal Fair Housing Act and effectively a reasonable accommodation for the marijuana smoking because of whatever particular issue there might be. And you have to balance the interest of the individual to smoke and he's duly licensed to do so versus a point that gets crossed where, well, now it's just too much and we can't tolerate the smell of the marijuana. So there's not a real good answer on that one, other than you got to kind of look at it from a case-by-case basis. And if there's any qualifications on the license for the marijuana smoker, does it have to be all day long or could it be occasionally when needed? And you have to balance the interests of that versus the neighbors who are aggrieved. I will say that the marijuana thing becomes very sensitive to certain people sometimes because of the odor, sometimes because it's technically illegal in Florida, or at least most places in Florida. But marijuana smoke has less impact upon health than cigarette smoking for sure.
There's other forms that you can use to ingest medical marijuana. Is an association able to inquire into that? Like, why are you smoking the medical marijuana as opposed to an edible?
Very good point. And that goes back to a reasonable accommodation for the person with effectively a disability, something that required them to get a license to smoke or use marijuana. And you are absolutely correct. It's not an absolute license for someone to necessarily smoke all the weed that they want to when there might be another alternative.
I can tell you from experience that every medical marijuana claim I've had in my client buildings, when we asked for the documentation, it suddenly became very apparent it was recreational usage, and then it stopped. So I don't know what your experience has been, but that was my experience.
For better or worse, probably I guess worse, there are unfortunately many medical doctors who are willing to prescribe marijuana for many patients, whether rightfully or not.
And look, for some people suffering from macular degeneration and other types of diseases, it is a wonder drug for that. And we get it. But again, it has to be reasonable usage in a building where you can impact others.
In drafting the amendments, I tend to not include that as a prohibited thing to be used or smoked on the condominium. And I do that because research shows that there's many more people who smoke or use marijuana than those who smoke tobacco. And because of that, going back to the practicality of we want this amendment to pass, sometimes prohibiting marijuana will not allow you to really get to your bigger goal of prohibiting tobacco smoking.
Well, that's a great segue into my next question, because you've had an interesting twist in your career. You became a developer a few years back, and you built several condominiums that were smoke-free from inception. So I want to know if you built those and you applied marijuana to those smoke-free condos. But first, I want to ask you, what inspired you to become a developer?
I've always practiced law 100% of the time, and with the other 100% of my time, I do other things such as real estate endeavors, and developed about 6 condominium buildings, 4 of which are in Fort Lauderdale and are no smoking buildings from inception. Apartment buildings, they could be no smoking from inception because there's one owner for it, and the owner of that building rents their units out, and they don't want deterioration or third-hand smoke on the carpeting and the furniture and whatever. The owner of the rental building might be more inclined to prohibit smoking, and a lot of them do. For condominiums, the concern for developers always is, well, will I not be able to sell all my units as a result? Is that going to hurt my marketing? I do believe that myself and my partner were the first in, and probably still are the only in the country as developers who from inception put no smoking language in the declaration of condominium. It was my belief from experience and some research that in addition to it being the proper thing for the environment and our culture and for health and safety reasons, I also believe that more people would be drawn to our buildings than less if we had no smoking prohibition. I did exclude marijuana from that for the reasons that I just said. And I got into developing, something I always wanted to also do because I've represented many developers, real estate developers over the years, and learned a lot from them. And I thought I could do the same. And fortunately, the projects were pretty successful. And even more importantly, I think there was a lot of publicity gained through those buildings being smoke-free, and hopefully will serve as a model for others in the state or the country for developers to consider making their buildings from inception no smoking.
Oh, I think there's a definite appeal, Dennis, to buying in a smoke-free building. Again, for somebody like me who's highly allergic to smoke, my options would be limited, I guess, to the 6 buildings you created. But that's what I would be looking for if I moved into a multifamily building, because what we've been talking about throughout this episode is how disruptive it can be to your life if you happen to be living next door to a chain smoker. Somebody who's producing an excessive amount of secondhand smoke and it's leaching into your unit, or when you walk down the hallway, you're smelling it every time. So I think there's a definite appeal to a smoke-free building from inception. Have all those buildings remained smoke-free?
Yeah, absolutely. Because buyers who originally bought, and I presume then mostly whoever resales may go to, would be interested in that. And I think once a building is smoke free, it's kind of like one of those things you're not going to be going back on and getting a vote to say, hey, let's now pollute our building and allow smoking in it. I don't foresee it ever happening really in a condominium building.
What I do foresee is buildings that want to be smoke free, let's say even inside the units completely, but who also allow short term rental activity. I think that could be problematic because you've got people cycling in and out on those short term Airbnb type rentals. And, look, if I'm only going to be in there for 3 days and you tell me it's a non smoking building, but I'll be gone by the time. Yeah. So I do think that could be a tension point if you try to be both of those things, short term rental friendly and a completely smoke free building. What do you think?
I agree 100%. And I think, though, that if someone buys into a building that does allow transient residency and short-term residency, then you have to accept the fact that you're going to be taking the issues and problems that might come with transient occupancy, including but not limited to smoking.
So as if you didn't have enough on your plate with everything we've been talking about, setting up your own firm years ago, managing that firm, becoming a developer, you also are an adjunct professor of law at the University of Florida. Tell me about that. I mean, do you think that there's sufficient interest among the next generation of lawyers to do what we do, dedicate their careers to representing community associations?
Maybe today, but I started teaching in 2004 at the University of Florida Law School for 2 reasons. One of which was that very thing that I felt that there was nowhere near the necessary people coming out of law school who would know anything about condominium law and would want to be practicing that area. There was a tremendous shortage, and the industry has grown significantly over the last 20 years, and I'm very, very happy about that. I'm happy to feel that I may have contributed to that. I've always had a tremendous attendance in my classes since 2004, and many, many, many of them ultimately became or are becoming community association attorneys. At that time, in 2004, I believe the only law school that also taught a condominium class was the University of Miami, and I think it was a postgraduate part of the LLM program for So there was just no education to law students. Now most of the law schools do actually include it. So that was the reason. I have a quickie secondary reason, which was my oldest son started at the University of Florida that year, and I went up to University of Florida, and I said, I'm going to figure out some way where I want to get to see him once a week at least, very close family. And my choices were walking into the law school and seeing if I could get a job. It's called a job, but it's not really paying. But a job at the law school to teach condominium law, or walking on as an assistant coach to the Billy Donovan at the University of Florida basketball team. That latter one didn't work, but when I walked into the law school, after them asking me what condominium law was, then they said, sure, put together a curriculum.
I have a Gator son, too. I should have thought of that idea. I used to visit him all the time in Gainesville. So good for you. That was a great idea. But, I mean, I don't know. When I was in law school, I never told anybody, hey, I want to be a condo lawyer when I graduate. Did you? Did you even know about condo law when you were in law school?
Yes. The first thing I did outside law school, actually still living in Gainesville for about 6 or 9 months, and there was a legal research company up there that did research for lawyers behind the scenes. And the one thing that they got into was also preparing ghost writing condominium documents. And that's actually how I got my start, because I ended up learning how to draft condominium documents before I actually really practiced law for any client.
Well, I think we both know that this area of the law isn't going to go away, because the hundreds of thousands of associations throughout the United States are not suddenly going to vanish. So this is a pretty solid practice area for attorneys to, dedicate their lives to. They know about it and they have interest in it. And I've also found it to be a diverse representation. It's not just about knowing the statutes.
Yeah, well, I'm sure you say the same thing I do when you publicly speak, and that's in Florida. About near 65% of our population lives in a community association governed by a recorded set of documents that also provides for lien rights if you don't pay, and possible loss of your property. That's a tremendous number. And every day that goes by, that percentage increases rather than decreases, because except for a few condominium terminations here and there, there's always more community associations created than the day before. And that's why it's very, very important to our state in particular. And therefore, it has become and should be a significant practice area for young attorneys.
And even in the homeowner association space, when's the last time you've heard of, occasionally there will be custom homes, but developers are putting all of these within a mandatory HOA framework. So I agree with you.
Yeah.
You were on the board of the American Lung Association South Florida chapter for a number of years. How does that organization help communities who are looking to become smoke-free communities?
One of their significant policies, tenets is exactly that, is the goal of making community association buildings, apartment buildings as well, smoke-free. And they are very passionate about that, and they devote a lot of time and money for education and for lobbying at the federal level and also within certain states to try to put that message out. Locally, South Florida chapter of the American Lung Association will call upon individuals sometimes to go visit with communities who have inquired about the possibility of making their building smoke-free and or preparing amendments for their consideration. So they are doing their part to get the word out. It's a really good organization.
They provide signage, don't they? The smoke-free signage for the communities, if I recall.
I don't remember if they do it for the communities themselves. I know that they did it for parks and beaches over the last few years, even before possibly it was permissible to restrict smoking within parks and beaches. They had created some signage that encouraged people not to smoke in those areas.
So for anybody listening who wants to consider going smoke-free in the community, the American Lung Association, wherever you are in the country, has some incredible resources that you can share at your membership meeting as you kind of workshop this idea of potentially passing a smoke-free amendment. So Dennis, I want to thank you for being here. Any final thoughts on why and how communities should consider going smoke-free?
Florida in particular is what I would deem to be a healthy state. We have 12 months of good weather a year compared to northern states. And a lot of people flock down here because they want to exercise and be healthy and live in a healthy environment. So I just think that living in a healthy environment goes hand in hand with not having to inhale secondhand smoke from others and live longer and better.
Thanks so much, Dennis.
Well, thank you, Donna.
Thank you for joining us today. Don't forget to follow and rate us on your favorite podcast platform or visit takeittotheboard.com for more ways to connect.